The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial.
And those are the words that turned this ridiculous war-winning case into a firestorm. And as the fallout continues, we have movement on one front. So welcome to The Point. Let's get to it.
Copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use.
Everything said here is alleged. Please do your own research and form your own opinion, and let me know that opinion down in the comments below, because this is an open discussion channel. But we have an update on the civil suit and the Katen Rear story. And I honestly didn't think this type of comment would be made. The real question here is this just legal posturing for show, or does the O'Keefe family actually believe this?
An update in the Katen Rear trial occurred this week as she requested a delay in the wrongful passing lawsuit filed by the family of her late Boston police officer boyfriend until after her criminal trial, where she faces charges related to his passing.
And we're fair on this channel, and if more fair coverage and an open conversation is something you prefer, subscribe to this channel and hit that like button down below. Because I originally thought the O'Keefes just filed that motion to get it on the docket, and neither side was really interested in pursuing this civil suit until after the trial. Which you would think makes the most sense, right?
The wrongful passing lawsuit filed last month holds Read responsible for the passing of John O'Keefe, along with alleging negligence by the bars that served her alcohol despite visible signs of intoxication. According to the lawsuit, the first bar served Read 7 drinks in about 90 minutes on the night of January 28, 2022. She then brought a drink with her to a second bar, where she was served a shot and a mixed drink within the next hour.
And given how the trial went, does this civil suit hold any water to you? Because C.F. McCarthy's has responded, which we'll get to at the end of the video, and that response is a common theme within this story.
On Wednesday, Read's attorneys filed a motion to postpone the wrongful passing lawsuit trial until after her criminal proceedings are complete. She is accused of striking John O'Keefe with her SUV and abandoning him in a snowstorm in January of 2022.
Which we know to be false because the science doesn't lie. And if you're about to make that lack of evidence statement based off a small part of the testimony, my question to you is, how do you prove beyond a reasonable doubt with a lack of evidence according to you?
Read's initial 2-month trial ended in a mistrial in July, but a new trial is set to begin on January 27th. She has pled not guilty to charges of second-degree passing, while driving under the influence and leaving the scene of a fatal accident. In a motion, Read's legal team said a stay is appropriate here, where proceedings with this civil action at the same time as the criminal action will adversely affect Miss Read's Fifth Amendment rights and her ability to vigorously defend herself from criminal prosecution. The motion also noted that the requested stay is minimal and not prejudicial, citing the fact that the wrongful passing lawsuit will not likely be finished until after August of 2027.
And regardless where you fall in this story, that statement is true. Because some of Katen Rear's defense would require her to give testimony. But waiting till the end of the trial benefits both parties, and we'll get to that in a second.
An attorney representing John O'Keefe's brother, Paul O'Keefe, and other relatives who filed the wrongful passing lawsuit opposed any postponement. The attorney argued that Katen Rear's use of the Fifth Amendment is undermined by her numerous public statements to the media about the case and her involvement in at least one up-and-coming documentary.
I've said it several times on this channel that I'm sympathetic to the O'Keefe family, and I really am. Don't the wheels of justice move so slow sometimes you would think they were square? And John O'Keefe does deserve justice, point blank period, and I don't see it any other way. But what's said in one trial will be used in the other. And like it or not, defendants have rights. It's a steep hill down also when we start whittling away at those rights. Not to mention, pushing for this civil suit is a double-edged sword. If the O'Keefe family speaks at this civil suit and they lose, those statements along with that loss will be used against them in the criminal trial. Now, of course, that would mean in some way, shape, or form that the criminal trial is delayed a little bit, which doesn't seem likely, but honestly, why risk it? The only way you're going to get justice for John O'Keefe is through charges, correct? And Paul does seem so certain in his interviews that Katen Rear actually did this. Unless they're thinking they've already given testimony. and they want something on record from Katen Rear. But once again, like it or not, Katen Rear has rights, and she shouldn't be forced to testify in this civil suit or make any statements about her words and paperwork involving this civil suit until after her criminal trial. She has rights, and we got to protect those rights at all costs, because that's what's going to ensure our rights as citizens. But it gets real accusatory here, so listen to this.
Mark Diller, an attorney for Paul Okeefe, said Miss Read consistently and voluntarily disregards her Fifth Amendment privileges as she attempts to craft her own narrative and poison the jury pool for both her criminal and civil cases. In light of her open willingness to speak publicly, Miss Read's current reliance on her Fifth Amendment right to silence appears to be less about avoiding self-incrimination and more about controlling the narrative to suit her interests, Diller said.
I see what he's saying to a degree, but let's pump the brakes a little bit. Yes, Katen Rear is giving interviews, which is her right at the end of the day because she's still a citizen of the United States. But is this her crafting a narrative, or is she simply trying to defend herself? Because some perspective is missing here. Let's keep in mind which family has a lot of pull in that town. And they've been saying what they've been saying all over town and in the media. Proctor was saying what he was saying, and the freaking DA gave a full-length video making the comments that he made. Now, to me personally, and you can disagree, but that's a whole lot of authority figures making the same type of statement and pointing that finger in a particular direction. And their words would carry a lot more weight than Katen Rear's. So who's poisoning the jury pool here? I'm honestly asking, because if I'm wrong, but that's just how I see it.
The wrongful passing lawsuit filed in Plymouth Superior Court by Paul Okeefe on behalf of his family and his brother's estate names Katen Rear, the Waterfall Bar and Grill, and the bar restaurant C.F. McCarthy's as defendants. The suit is seeking a jury trial.
Now, C.F. McCarthy has responded to this lawsuit, and keeping with the overall replies from Katen Rear's defense and a lot of creators on this platform, they basically said, and I'm paraphrasing here, but prove it. Where's the proof here? Which is what we've been asking here this whole time. Since this investigation was allegedly conducted fast and loose, with no regard to standards or procedures. At least that's how I saw it, and you can feel free to disagree down in the comments below. But I felt like they decided pretty early on that no one else would do this argument would hold up. And that people were just going to fall in line like sheep and not question things. As if law enforcement is incapable of committing a mistake or committing a crime, while at the same time drinking and getting behind the wheel of a vehicle. I mean, you honestly can't make this stuff up. Now, it's my understanding that the rules of evidence in these civil suits is a little bit loose. But where's the proof, right? Trying to do anything in this civil suit before the criminal trial is over is foolish in my own unprofessional opinion. And if you disagree, let me know down in the comments below. Y'all be safe now.